Hello and welcome to this evidence video capsule. And today I want to focus on settlement privilege, a very important evidentiary rule that's applicable to every single type of proceeding. It is designed with one purpose in mind: to allow people to communicate freely in the hope of settling their legal disputes without worrying that what you say for the purpose of trying to reach a settlement is then used against you. Now keep in mind that the whole idea of privilege is that there is some social interest that is important enough to warrant setting aside relevant and probative information. And let me tell you, there are few privileges based on rationales more important than settlement privilege. They go to the very core of how our justice system really needs to function if it's going to work in any type of effective way. And settlement privilege, not surprisingly, arises in the context of settlement discussions between these two people who are having a dispute. And it is not uncommon in settlement discussions to admit to positions that are contrary to your position in litigation. Whether you are really doing it, whether you are doing it for the purpose of trying to move things along, the entire idea of settlement and settlement discussions is that we encourage people to speak freely. Very similar in a sense to legal advice privilege. We encourage people to speak to their lawyer freely so that they can understand what to do next. In settlement discussions, we create a zone of privacy in which people can admit to things that may be contrary to their position. We do that to encourage them to settle their disputes. Now, this makes a lot of sense, but look what would happen if we didn't protect what was said in these conferences. I mean, this is the worst case scenario in a settlement conference. You make an admission, and let's be very clear, our rules of evidence would admit this type of evidence. It amounts to a party admission, which is ordinarily admissible against the hearsay rule and could be used against this party. That would be a disaster. The rules of settlement privilege make it clear that we want to do everything we can to encourage settlement to take place. So therefore, we have crafted a very broad privilege that is designed to allow people to speak freely in any form of settlement negotiation. Let's look at some of the basics. First, as just a sort of an overview, keep in mind this is often referred to as the without prejudice rule. And the reason for that is that most lawyers have a habit, or a historical habit, of signing their letters without prejudice, which typically means without prejudice to my client's position. In other words, I write this letter and I don't want you to use it. You are unable to use it against me for the purpose of any admissions that might be contained therein. The courts have made it crystal clear that the wording without prejudice on a letter does not bring it within the privilege. In other words, it is simply an indicator that you may wish to be making this as part of a settlement discussion. But ultimately, whether or not a communication falls within settlement privilege requires a substantive evaluation of the nature of the conversation and the rationale of settlement privilege. Are we in the midst of discussing the resolution of a dispute? Now, settlement privilege traditionally is directed to preventing admissions from being tendered, but I don't want you to think that's exclusive. The Supreme Court, in a series of recent cases, the most significant being a case called Sable versus Amaron, has made it clear that we want to protect everything. We are not going to allow material to come out of a settlement discussion if we don't have to. And we will look at some exceptions in a moment, but there has to be a pretty strong reason for setting aside the privilege. We're going to protect everything: admissions, non-admissions, settlement discussions, background negotiations, even the settlement agreement. If we believe that they were all made and go to the rationale of the privilege, which is the need to encourage discussion, we're going to let people speak freely. We're not going to get down to technicalities about what constitutes an actual admission. So subject to the exceptions, settlement privilege is exceptionally broad in terms of its scope. And here's the key limitation. Any statement that's going to be protected by settlement privilege has to be made in a bona fide attempt to settle a dispute of any kind. And that means real or apprehended. What I mean by apprehended is even preliminary discussions where no litigation has been launched can be protected by settlement privilege. The key is whether the party who makes the communication is acting bona fide in good faith to settle the dispute in some fashion. You do not need to have lawyers involved. I mean, it's nice if you do and you have without prejudice written down, but it is not an ironclad requirement. Any settlement dispute discussion where you are really trying to engage, even if it's rejected, the other side may reject the discussion and try and use your admission against you. They can't do that. If you are making a bona fide attempt to settle, it may be an opening foray, a letter saying, I'd like to settle this. We're prepared to, admit to these sorts of things. Why you would do that and risk it is beyond me. But let's assume that it is done. I still believe those types of communications would be protected. Obviously, formal settlement proceedings are the most common and are the most protected, but the courts have made it clear that settlement privilege is just too darn important. We want disputes to go away. This is also true, as I said earlier, in criminal cases. Plea bargaining discussions between counsel are always protected. You never see a Crown trying to raise this subject to some of the exceptions I'm going to look at, but defense and Crown get into negotiations. Even an accused representing themselves gets into discussion saying with the counsel, perhaps goes up to Crown counsel and says, yeah, I did it, but I'm hoping you can do me a solid on the sentence, or perhaps a reverse. I'll admit to it if you give me a break on sentence. Those are conditional admissions, and they are made in a bona fide attempt to settle the case. You cannot have those used against you suddenly where they are made in a good faith effort. The exceptions to settlement privilege are fairly limited. The first, I don't even think this is an exception. This is one of those situations you can argue about whether it's an exception or just doesn't fall into the privilege. If you make threats, or it's not threats of fraud, or threats or fraud, that's a problem. So, for example, where you put something in a settlement discussion that is fraudulent, you're going to be out. That's not a bona fide attempt to reach settlement. Threats is a tricky one. You've got to read the word threats carefully, because, for example, certain threats are not problematic. I think what we're looking at is illegal threats or onerous threats, because certain threats, for example, if you don't settle with me, I will sue you. Well, that's just the threat of ongoing litigation. That's no problem. The courts will certainly look at whether the parties are bargaining in a good spirit, in a fair spirit. In those types of situations, I would still say you have a bona fide attempt to reach settlement. The question is whether the threat is illegal. Obviously, if you don't pay me, I'll break your face, or some sort of onerous obligation. The courts have looked, for example, in the commercial setting to situations where a firm would say, well, settle with me or we will devalue your stock price by releasing this information into the market. Types of things like that become sort of borderline, they're unethical or they cross some sort of invisible line. But let me be clear, hard bargaining, the threat to continue pursuing the litigation, things along those lines, do not fall into this exception. Exception number 2 is a little bit trickier. This is a situation in which we need to go behind the privilege to uncover a disputed aspect of the settlement. So, for example, sometimes you will draft a settlement agreement and the terms will be a little bit unclear. So both parties will sign and then there will be a difference in interpretation about what the settlement means. In those circumstances, you can go behind the settlement to the communications that preceded what happened, even though those are ordinarily privileged. They were made for the purposes of reaching a settlement. But if you need to understand what's in the settlement, you are allowed to go behind it where necessary to interpret what happened. So maybe there's a recording of the discussions or one party took notes of the discussion. Those would ordinarily be privileged, but not where we need to understand what was actually meant or there's a dispute of some kind. This also comes up in some other areas that are a little bit trickier, and I would say the biggest is a situation where you have separate proceedings. So let's say, for example, that Party A is suing Party B and Party C, and A and B reach a settlement for some portion of the damage, and they kept it secret. They've negotiated in good faith and they've settled, but C wants it. C wants to know what's in that settlement so they can make decisions about their own position. Well, let's just say this is a very complex area, but generally speaking, the courts have realized that, if there is a risk of what's called double recovery, so the worry that A will recover twice as much as they're entitled to, there are situations in which some aspects of settlement discussions or agreements may need to be released. And generally, the rule of thumb here is where there's a likelihood of there being some unfairness if that amount or information is not revealed to another party. So let's be clear.
Settlement privilege, very simple to understand and should be reasonably simple to be able to apply when it exists, but it's an extremely important privilege that won't be set aside lightly. The exceptions that you're looking at here are really situations in which there really is no privilege information at all because the communications were not made in a bona fide attempt to reach settlement, or it's simply necessary to look at some aspects of the settlement. But I can tell you that the core of the protection, which is to protect against admissions that will be harmful to your case, those are unlikely to be let out freely. As I said, the core of the privilege is to allow parties to talk freely. So you might have to give up the amount that you settled for. Very unlikely. I've never seen it done, except in the threat fraud situation where admissions are held against you at a later time.
That's it for settlement privilege, which is a fairly straightforward but very important form of privilege. Don't underestimate how important it is. It is used every single day to allow parties and lawyers to negotiate in good faith together without fear of repercussions. I hope you got some use out of this capsule, and have a great day. To learn more about this topic, you might want to check out my book, The Law of Witnesses and Evidence in Canada, published by Thomson Reuters. This book covers every topic involving the law of evidence and also how witnesses come before courts and tribunals in criminal, civil, and administrative proceedings. To learn more, you can check out my website at petersankoff.com.